Thank you, Mr. President. I rise to give my no vote explanation on House Bill 5949. I noticed as we were reviewing the legislation we were going to take up today that this bill in particular, this is something that creates a new act for the state of Michigan. So by passing this, I think it's a pretty big deal. We're going to be adding a new law to the books. And I personally think it's important that if we're going to do that, especially at this moment in time, that we take the time as a chamber to understand what's in this bill. What is this new act going to be? So I've printed out portions of it, and I want to go through some of that with the chamber. So the substitute that we just voted on for House Bill number 5949 is a bill to provide for peer-to-peer car sharing, to impose obligations on and provide rights to persons that operate peer-to-peer car sharing, shared vehicle owners, and shared vehicle drivers, to provide for liability for personal injuries and property damage in peer-to-peer car sharing, to provide for responsibilities of insurers, and to provide remedies. Section 1 says that this act may be cited as the Peer-to-Peer Car Sharing Program Act, which even though I voted no, I don't have a problem with the title of the bill. Seems fine to me. And as we move on, I don't want to miss anything here, but Section 3 talks about some of the definitions. Sometimes these things are boring, but they are important as we're changing the law in Michigan. So in this act, automobile insurance means that term as defined in Section 3303 of the Insurance Code of 1956, 1956 PA 218 MCL 500.3303. And then car sharing delivery period means the period of time during which a shared vehicle is being delivered to the location of the car sharing start time, if applicable, as documented by the governing car sharing program agreement. Car sharing period means the period of time that commences with the car sharing delivery period for, if there is no car sharing delivery period, that commences with the car sharing start time and in either case ends at the car sharing termination time. I can understand where they came from in creating these definitions. It seems to make sense to me. Again, I don't object to anything that I've read so far. We'll get to the troubling parts of this legislation later. But it is, as I said, important to understand how all of this fits together. The car sharing program agreement means the terms and conditions applicable to a shared vehicle owner, a shared vehicle driver, and a peer-to-peer car sharing program that govern the use of a shared vehicle through a peer-to-peer car sharing program. Car sharing program agreement does not mean or include either of the following: a car rental agreement by a car rental company, as that term is defined in Section 3H of the Michigan Consumer Protection Act, 1976 PA 331 MCL 445.903H, or a similar agreement, nor does it mean an agreement for a transportation network company, pre-arranged ride, as that term is defined in Section 2 of the Limousine, Taxi Cab, and Transportation Network Company Act, 2016 PA 345 MCL 257.2102. Car sharing start time means the time when the shared vehicle becomes subject to the control of the shared vehicle driver at or after the time the reservation of the shared vehicle is scheduled to begin, as documented in the records of a peer-to-peer car sharing program. Car sharing termination time, on the other hand, means, except as provided in Section 41, the earliest of the following: the time the agreed upon period of time established for the use of the shared vehicle expires according to the terms of the car sharing program agreement, if the shared vehicle is delivered to the location agreed on in the car sharing program agreement, and the time of the return of the vehicle to a location that is alternatively agreed on by the shared vehicle owner and shared vehicle driver, as communicated through the peer-to-peer car sharing program, which alternatively agreed on location must be incorporated into the car sharing program agreement. The time the shared vehicle owner or the shared vehicle owner's authorized designee takes possession and control of the shared vehicle. Peer-to-peer car sharing means the authorized use of a vehicle by an individual other than the vehicle's owner through a peer-to-peer car sharing program. Peer-to-peer car sharing does not include either of the following. First, it doesn't include car rental or rental activity by a car rental company. as that term is defined in Section 3H of the Michigan Consumer Protection Act 1976, PA 331, MCL 445.903H. A transportation network company, prearranged ride. I think we've covered some of these already in the other definitions, so I'll move on. Peer-to-peer car sharing program means a person that connects vehicle owners with drivers to enable the sharing of vehicles for financial consideration. Peer-to-peer car sharing program does not mean or include any of the following: a car rental company, as that term is defined in Section 3H of the Michigan Consumer Protection Act 1976, PA 331, MCL 445.903H, or a transportation network company, as that term is defined in Section 2 of the Limousine, Taxi Cab, and Transportation Network Company Act 2016, PA 345, MCL 257-2102. I might be getting a suggestion that we should move more quickly through this. It is a complicated piece of legislation that, as I said, impacts the state. But let's move on to the substance and pass some of the definitions, as I know that can be a little bit boring to listen to. So as this act starts to talk about insurance itself, we move on to Section 41, Paragraph 1. Except as provided in subsection 2, a peer-to-peer car sharing program shall assume the liability of a shared vehicle owner for bodily injury and property damage to third parties during the car sharing period in amounts stated in the car sharing program agreement, which may not be less than those required under Section 309 of the Insurance Code of 1956 PA 218 MCL 500.3009. This is where I begin to have a major problem with this piece of legislation. As the people of this chamber well know, and the people of Michigan, the topic of vehicle insurance is a very serious topic. Insurance rates are too high. Many in this chamber worked for years at various types of solutions to try to solve some of the woes of the people of Michigan when it comes to the price of their auto insurance. My problem is that we're going to stand here today and take up such a weighty topic that involves a section of law that intersects with automobile insurance, and we're going to do it on one of the last session days of the year with very little debate on the topic. I think I'm the only one debating this topic at this point. And we're just going to throw it up. And who knows what's going to happen? How much will auto insurance cost next year? What will the impact of this program be on our auto insurance rates? I don't know. Does anyone here know? But that's not the only problem. As we continue, we'll see even more problems with this legislation. Notwithstanding the definitions of car sharing termination time in Section 3, the assumption of liability under subsection 1 does not apply to a shared vehicle owner if the shared vehicle owner does either of the following: makes an intentional or fraudulent material misrepresentation or omission of the peer-to-peer car sharing program before the car sharing program period in which the loss occurred, or acts in concert with the shared vehicle driver who fails to return the shared vehicle in accordance with the terms of the car sharing program agreement. Continuing on, notwithstanding the definition of car sharing termination time in Section 3, the assumption of liability under subsection 1 applies to financial responsibility requirements described in Chapter 5 of the Michigan Vehicle Code. Now, at this point, unless anyone in the chamber objects, I'm actually going to stop reading the references to other laws, but you can check the legislation yourself, and they're all enumerated. But as we continue on, we'll see that a peer-to-peer car sharing program shall ensure that during each car sharing period, the shared vehicle owner and the shared vehicle driver are insured under an automobile insurance policy that either recognizes that the shared vehicle insured under the policy is made available and used through a peer-to-peer car sharing program, or that does not exclude use of a shared vehicle by a shared vehicle by a shared vehicle owner or a shared vehicle driver. The peer-to-peer car sharing program shall ensure that the automobile's insurance required under this section provides all of the following. But before we go to the following, that paragraph alone, if you look at it, was complicated enough that I think it bears repeating. A peer-to-peer car sharing program shall ensure that during each car sharing period, the shared vehicle owner and the shared vehicle driver are insured under an automobile insurance policy that either recognizes that the shared vehicle insured under the policy is made available and used through a peer-to-peer car sharing program, or that does not exclude use of a shared vehicle by a shared vehicle owner or a shared vehicle driver. The peer-to-peer car sharing program shall ensure that the automobile insurance required under this section provides all of the following. And if we start going through what it mandates to be under these sections, again, what are the implications for auto insurance in Michigan? What is this program going to do? What is it going to cost the people? It's frustrating to see this sort of policy brought forward so quickly without proper debate. But I'm going to, I think I've made that point, and I hope that the other members in the chamber will agree. So there were a couple of other things that I want to fast forward to and address quickly in this legislation. If we go on to the Consumer Protection Disclosures, Chapter 5, Section 51, a car sharing program agreement made in this state must disclose all of the following to the shared vehicle owner and the shared vehicle driver. Any right of the peer-to-peer car sharing program to seek indemnification from the shared vehicle owner or the shared vehicle driver for economic loss sustained by the peer-to-peer car sharing program that results from a breach of the terms and conditions of the car sharing program agreement, that an automobile insurance policy issued to the shared vehicle owner for the shared vehicle or the shared vehicle driver does not provide a defense or indemnification for any claim asserted by the peer-to-peer car sharing program, that the peer-to-peer car sharing program's insurance coverage on the shared vehicle owner and the shared vehicle driver is in effect only during each car sharing period, and that for any use of the shared vehicle by the shared vehicle driver after the car sharing termination time, the shared vehicle driver and the shared vehicle owner may not have insurance coverage. And I will be honest to everybody here, when I finally reached this portion of the law is when I thought, maybe I'm wrong. They've done some good work here, it seems to me. And I actually considered being in support of the legislation, because some of the very questions that I asked early on, I said, what about the insurance implications? I will admit that in this portion, some of those are addressed when we talk about indemnification and how it's all going to fit together. But still, this is a new act. We're adding laws to the state of Michigan if we pass this. Shouldn't it have a lengthy, proper debate? The daily rate, fees, and if applicable, any insurance. Oh, I'm sorry. Fellow members, I already read that paragraph. The shared vehicle owners or the shared vehicle driver's automobile insurance policy might already provide the coverage required by this act depending on the terms of the policy. An emergency telephone number to personnel capable of fielding roadside assistance and other customer service inquiries, which itself is kind of, if you think about it, after we adopt this, where is technology going to go? And having this sort of requirement in there and having like a phone number, it doesn't even make sense to lock us into that sort of system. If there are conditions under which a shared vehicle driver must maintain a personal automobile insurance policy with certain applicable coverage limits on a primary basis in order to book a shared motor vehicle. That, in accordance with sections 300, again, read for yourself if you're deeply interested in this. But in section 52, we continue on to a peer-to-peer car sharing program shall not enter into a peer-to-peer car sharing program agreement with an individual unless the individual will operate the shared vehicle and satisfies one of the following. The individual holds a driver's license issued under the Michigan Vehicle Code, 1949, PA 300 MCL 257.1 to 257.923, that authorizes the individual to operate vehicles of the class of the shared vehicle in the state, or the individual is a non-resident of the state to whom both of the following apply. So you got kind of forks in the road. It could be either of these things, but in option 2, there are other forks that we go down. The individual has a driver's license issued by the state or country of the individual's residence that authorizes the individual to drive vehicles of the class of the shared vehicle in that state or country, or the individual is at least the same age as that required of a resident of this state to drive. I'm not sure that's enough of a safeguard. Again, this is one of those areas that raises a bit of a flag to say, who are we going to allow driving these vehicles, entering into these agreements? Can people come from all over the world? Are we putting the right types of requirements on them? I'd like to see a lot more of a deep dive into this before we just throw a new law on the books. And then, of course, C, the individual is otherwise specifically authorized by the law of this state to drive vehicles of the class of the shared vehicle. That seems logical. A peer-to-peer car sharing program shall keep a record of all of the following: the name and address of the shared vehicle driver. And let me just stop there and say, the moment we enter into something like this, a peer-to-peer car sharing program shall keep a record of all of the following. So right out the gate, these companies, we want to set up this law, we want to set up an opportunity to do this sort of economic activity, and right out the game, bam, we're going to tell anybody that does this, you got record keeping. This is regulatory burden right from the outset on these sorts of arrangements. Why do we need these sorts of record keeping? Well, let's read on and figure out. They have to keep the name and address of the shared vehicle driver, the number of the driver's license of the shared vehicle driver, and each of their individuals, if any, who will operate the shared vehicle. Seems to me that could be read that they would have to predict the future, but maybe not. Maybe the verbiage is proper. I'd like to, again, look into it. The place of issuance of the driver's license identified under subdivision B. And then section 53, a peer-to-peer car sharing program has sole responsibility for any equipment such as a GPS system or other special equipment that is put in or on the shared vehicle to monitor or facilitate the car sharing transaction, and shall agree to indemnify and hold harmless the shared vehicle owner for any damage or theft of the equipment during the car sharing period not caused by the shared vehicle owner. The peer-to-peer car sharing program has the right to seek indemnity from the shared vehicle driver for any loss or damages to the equipment that occurs during the car sharing period. When a vehicle's registered owner registers as a shared vehicle owner with a peer-to-peer car sharing program, and before the shared vehicle owner makes the shared vehicle available for car sharing through the peer-to-peer car sharing program, the peer-to-peer car sharing program shall do both of the following. A, verify that the shared vehicle does not have any safety recalls on the vehicle. I mean, seriously, is anybody here driving a vehicle that doesn't currently have some random recall notice on it out there? I mean, I can't go and get my vehicle serviced without seeing that, oh, boom, there's something from 2009 that your car was supposed to have fixed. And now we're going to tell them you can't even enter into these sorts of agreements if there's any sort of outstanding notice from the manufacturer. You can't even keep track of these things these days. But they have to if you want to engage in this sort of activity. Now that's something else you got to deal with. They also have to notify the shared vehicle owner of the requirements under subsection 2 and 4. And if a shared vehicle owner has received an actual notice of a safety recall in a shared vehicle, the shared vehicle owner shall not make the vehicle available as a shared vehicle through a peer-to-peer car sharing program until the safety recall repair has been made. If a shared vehicle owner receives an actual notice of a safety recall in the shared vehicle while the shared vehicle is made available through a peer-to-peer car sharing program, the shared vehicle owner shall remove the shared vehicle from being available through the peer-to-peer. Is this like while it's being driven, you got to call them up and say, get off the road right now, we'll come have a tow truck, come get you. I don't know how quickly they have to pull the plug on these just because you get a notice from a manufacturer that, there's a screw in the plastic on the door handle that's not attached properly and we've had problems, we need to recall it, so you got to go pull people off the road. I don't know if that's how this is going to work. But as soon as practicable, I don't know, after receiving the notice and until the safety recall repair has been made. If a shared vehicle owner receives an actual notice of a safety recall while the shared vehicle is being used in the possession of a shared vehicle driver, as soon as practicable after receiving the notice, the shared vehicle owner shall notify. And again, I don't know how that's going to be interpreted and what the requirement is going to be on them. You got to go out there, pull somebody out of the car. So, that pretty much brings us to the end of the legislation itself. And I want to say again, I think that when I reviewed this initially, I had some pretty favorable impressions of the bill, of the concept. It certainly is something that could add value to the state of Michigan. But we also, as legislators, have an obligation to the state that when we're going to add a new law to the books, that we spend the appropriate amount of time going through the process and debating it and really looking into this. And so while I could see value of this program, I had to vote no, and I appreciate the opportunity, Mr. President, to give an explanation of that, mostly based on the reasoning that I wish this legislation had been further vetted and we had taken more time, not waited until the day before, the potential last day of the session and sort of run it through at the last minute. So I thank you again for the opportunity to speak to the bill.